Welcome to Employment Law This Week. I'm George Whipple. Our top story, the High Court will kick off its October term by tackling a significant employment issue. The court will hear arguments on the enforceability of class action waivers and arbitration agreements. Oral argument is scheduled for October 2nd on related cases from the 5th, 7th, and 9th circuits. During the Obama administration, the NLRB took the position that such waivers violated employees' rights, and the Department of Justice agreed. The DOJ reversed its position in an amicus brief filed in June. While the NLRB has not done so, it is expected to revisit the issue after the new Republican majority is confirmed. Stuart Gerson has more.
There's a tension between the Federal Arbitration Act, which the Supreme Court has favored in a number of recent cases, and the National Labor Relations Act. And that's going to be resolved, and employers are sitting at the edge of their seat trying to find out whether it's the view of the National Labor Relations Board about concerted activity that's going to prevail, or whether, as has been the case in several recent cases of the Supreme Court, the court will hold that the Federal Arbitration Act takes primacy and that these class action waivers will be enforced and employees will have to litigate their claims individually.
The Trump Department of Labor will move quickly to undo an Obama-era regulation on tip pooling. The White House Office of Management and Budget issued its regulatory agenda last week, detailing planned actions by federal agencies. The agenda states that the DOL will issue a Notice of Proposed Rulemaking as soon as August to rescind a 2011 interpretation of the tip credit rule. The Obama-era regulation prohibited tip pools even when an employer pays employees at least full minimum wage. That rule was the subject of numerous legal challenges, including 2 cert petitions presently pending before the Supreme Court. The Justice Department says that Title VII does not prohibit sexual orientation discrimination. In an amicus brief filed last week, the DOJ told the Second Circuit it should reaffirm its earlier ruling that Title VII does not protect employees against discrimination based on their sexual orientation. The DOJ's interpretation directly contradicts the EEOC's official position on the matter. The case involves a skydiving instructor who was fired after disclosing to a customer that he was gay. As we previously reported, the Second Circuit has granted an en banc hearing in order to reconsider their holding on the issue. U.S. Citizenship and Immigration Services has issued another revised Form I-9. Employers will be required to use this new version, dated July 17, 2017, beginning September 18th of this year. Until that time, employers may use either the new form or the form dated November 14, 2016. Form I-9 is used to verify the employment authorization and identity of all employees in the U.S. The updated form includes a revised list of acceptable documents and small changes to the language. And that brings us to our tip of the week. Christina Blankley is here with some advice on best practices for improving employee engagement in benefit programs.
Employers should not underestimate the importance of employee engagement and the inevitable effect it has on a company's return on investment. Communications to employees about the company's benefit offerings throughout the year keep employees reminded of the benefits afforded to them as part of your organization. If a new gym opens up next door, send a reminder email to your employees that the company's insurance carrier offers a gym reimbursement program that they can benefit from. Employers should distribute to their employees an annual total reward statement. It is a document that shows an employee their total compensation by listing their wages alongside the value of each benefit the company offers. This educates the employee on their true worth as a team member within your organization and creates incentive to utilize benefits afforded to them.
Thanks, Christina. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.